transfer case item 8 second effect 293 of 2017.
Apologies, madam, there is a requirement of filing an application for additional substantial question of law. The substantial question of law has been framed on the ground of landlord-tenant relationship. Finding was given by the learned High Court, however, no finding has been given by the learned First Appellate Court. However, the suit as well as the appeal has primarily been dismissed on the ground that since it was a contractual lease, the Rent Control Act, the statutory requirements for eviction would not apply, which is against the law, because Rent Control Act itself says that notwithstanding any agreement to the contrary, and there are Supreme Court judgments as well. So that question of law has to be framed.
There is a finding that it will not apply.
There's a dispute that the agreement says that 4 months, or only on 4 months of default he can be evicted, and the lease is for a period of 28 years. But the Act says 2 months of default he can be evicted. That's a ground for eviction.
That's right.
So the court has returned a finding that he is protected by the agreement, despite the Act saying that in 2 months of default he has to be evicted.
Where is that finding?
Yes.
And where is the other side? Because additional question of law cannot be framed in the absence of the other side.
Yes,
You have to file an appropriate petition to that effect.
we'll find an application. I might be arguing against myself, but 2 days back also there is a Supreme Court judgment that a reasoned order has to be passed for claiming of it. We'll file an application. Come next Monday.
Essay number 293 of 2017. Counsel for the appellant is present. Nobody appears on behalf of the respondents. The learned counsel for the appellant has submitted that by virtue of order dated 25 to 2020, right has been reserved for formulating other substantial question of law at the time of hearing. He submits that an additional substantial question of law is involved in this case, for which he prays for time to file an interlocutory application. He submits that the matter be posted on next month. We do it by Friday.
Yes.
Serve the copy on that as well. And refer to the judgment also.
Yes.
Plaintiff simply formulate as to whether this finding is contrary to the judgment. Right? Post on next month.
For hearing under order 41 rule 11, item 38 second effect 452 of 2017.
इसमें कोई adjournment notice है?
जी.
कितना दिन का adjournment मांगे?
Up to date. उसमें बोल रहे थे मेनू का कॉपी नहीं है.
Yes.
Next week. कल मेंशन किए.
Essay number 452 of 2017. Counsel for the appellant is present. He submits that an advance notice seeking adjournment has been circulated in this case. At his request and by way of last indulgence, the matter is directed to be posted on the list.
ओरिजिनल फाइल मिल गया है, इसमें मेमो का कॉपी केवल नहीं मिल रहा है, बाकी सारा कुछ है. मेमो को कॉपी
तो आपको तो कोर्ट मास्टर साहब ने बोला था ना, सॉफ्ट कॉपी ले लीजिए. आपने तुमको बताया था, he told you that you take the soft copy.
Item 39, second appeal 484 of 2017.
My sincere apologies, madam. I could not convey advance notice for adjournment, madam.
No, we will not adjourn it. Those people who have not conveyed advance notice for adjournment, we will not adjourn.
But the only difficulty is that Mr. Neeraj was yesterday in Calcutta and he got wrong ticket and he reached today in the morning itself, madam. And he could not prepare himself, madam. So I am only praying for day after tomorrow, madam.
The case was adjourned upon payment of cost.
On the last
On repeated 8,000 रुपए cost तक अब तक पहुंच चुका है.
No.
1,000, 2,000, 4,000, 8,000.
I have seen the orders, madam. I am just only praying let it come day after tomorrow.
नहीं ऐसा नहीं हो सकता. इतना बार एडजर्नमेंट होने के बाद 2017 में अभी तक ऑर्डर 41 रूल 11 का आपका नहीं बना है. हम बिना कॉस्ट के एडजर्न नहीं करेंगे. अगर आपका हम बिना कॉस्ट के एडजर्न कर दिए तो हमको हर एक केस को बिना कॉस्ट के एडजर्न करना पड़ेगा. आर्टिकल 14 विल अप्लाई. हम नहीं करेंगे बिना कॉस्ट के एडजर्न.
May I pray for pass over for few cases, madam?
फ्यू केसेस मतलब आप 3 बजे चले जाएंगे.
May I pray for 3:15? There is one matter fixed in court number 6.
3:30.
Okay.
Item 40, second appeal 485 of 2017.
Are you appearing in this case? Second appeal number 485 of 2017. Nobody appears on behalf of the appellant. The matter has remained pending before this court since 2017. And the order sheet reveals that on 3/1/2023, the prayer for adjournment was allowed by way of last chance. Thereafter, the matter was taken up on 1/3/2023, and again the time was allowed, subject to payment of cost of ₹1,000. Then the matter was again taken up on 10/7/2024, and the time was allowed upon cost of ₹2,000. Thereafter, again on 30/9/2024, the matter was adjourned upon payment of cost of ₹4,000. And today, when the case is taken up, nobody is appearing on behalf of the appellant. Accordingly, this appeal is dismissed for non-prosecution.
Item 41, second appeal 498 of 2017.
As the plaintiff in the original suit, the suit was filed for partition of a specific property belonging to a joint family property. The plaintiff and defendant belong to a common ancestors. The suit for partition has been dismissed on two grounds. One is that firstly, there was a previous partition. Secondly, the registered deeds have been executed in favor of defendant number 2 and 3 who are the subsequent purchasers. And in the recital of the deed, it has been stated that subsequent to earlier partition, this deed is being executed. Now, the substantial question of law matters is that firstly, the court has completely ignored that there is presumption of jointness. The court has come to a finding that there is no presumption of jointness because it was admitted by the plaintiff that with respect to other properties, there was a previous partition. But with respect to this property, there is no such admission, no document has been brought on record, no evidence has been brought on record by the plaintiff. Secondly, the court has relied upon the registered sale deed, which I have challenged in this suit. So that if I challenge that registered sale deed, that cannot be relied upon to prove that there was earlier a partition. Thirdly, matters the London trial court did not even claim any issue with respect to the fact that whether there was an earlier partition or not. Whether there
Who
was
pleaded that there was an earlier partition? The defendant?
the defendant's plead. If you lordship may kindly see the findings, but before that I wanted to show the pleadings. If you lordship may kindly come to page number 36.
Yes.
Fourth paragraph, madam. It is submitted by the plaintiff that above mentioned plot number 224 is joint and legitimate property of Madhusudan Singh Chaudhary and said property was never partitioned by meets and bounds among co-sharers of heirs of late Madhusudan Chaudhary. Other plot have been partitioned between co-sharers after death of Madhusudan Chaudhary. It is further submitted that plaintiffs are heirs of one son of Madhusudan Chaudhary, therefore entitled for one-fourth share joint in plot number 224. It is further pleaded that if any sale deed have been executed by defendant namely Kailash Chand and Kashinath Singh and their mothers Sushila Devi wife of Simla Singh Chaudhary in favor of Devanti and Madhavati Devi in respect of total area of plot number 224 is forged and fabricated document. As such, defendant number 3 to 5 have no right to transfer entire 8 decimals land in
These
plot.
deeds were challenged?
Yes, and same deeds have been relied upon by
No, these deeds were challenged in the trade?
Yes, madam. The prayer is quoted in the fifth paragraph. C. Decree of declaration that may be passed to effect that safety number so and so executed by defendant number 3 to 5 in favor of defendant number 2 is void of. Now, if your lordship kindly come to the finding.
No, where is the issue regarding previous partition?
There was no issue regarding previous partition before the trial court. To the point of law was framed by the appellate court, that is paragraph number 15.
Just a moment. Has the trial court dealt with the issue of previous partition?
It has dealt with the issue, madam. That is one of the substantial questions of law that has been dealt with without framing any issue.
Let's see the trial court judgment. And where is the finding?
Running page number 23, madam, paragraph number 9.
Yes.
अभिलेख का अवलोकन किया मामले में पक्षों की ओर से प्रस्तुत गवाहों के साक्ष्य एवं दस्तावेजी साक्ष्य का अवलोकन किया। वादी के साक्ष्य को देखने से बिल्कुल स्पष्ट है कि यह वह पूर्व बंटवारा की बात को स्वीकार किए हैं, किंतु प्लॉट नंबर 224 के बंटवारे का नाम होने का बात कही है, किंतु अपने अभिकथन अथवा साक्ष्य में ऐसी कोई साक्ष्य नहीं दिया कि इस प्लॉट नंबर 224 का बंटवारा किन परिस्थितियों में पक्षों के पूर्वजों ने नहीं किया। सबसे महत्वपूर्ण बात यह है कि प्रतिवादी के साक्ष्य से स्पष्ट है कि सभी पक्षों के बीच समस्त संपत्ति का बंटवारा हो गया। यही कारण है कि केवला संख्या B और B1 में तकरारी संपत्ति के बिक्री के वालों में बेटा चक्रधर सिंह चौधरी ने उक्त केवला पर हस्ताक्षर कर वह स्वीकार किया कि प्लॉट नंबर 224 के पूर्व स्वामी मालिक सिंह लाल सिंह चौधरी के वारिसन हैं। यदि वह संपत्ति संयुक्त रहती तो उनकी भी हक व हिस्सा बनता और ऐसी स्थिति में वे भी बिक्रीनामा पर कभी भी हस्ताक्षर कर केवला निष्पादित न हो।
Shivlal Singh Chauhan is a common ancestor.
Yes, for the branch of the defendants.
So that's a different thing altogether.
Yes.
They are not the common ancestor.
He is
And
a common ancestor.
he is not the common ancestor of the plaintiff and the defendant.
So common
The
ancestor.
property was standing in the name of Shivlal Chauhan.
Yes. Madhusudan Singh Chaudhary.
No, this property was standing in whose name?
Madhusudan Singh Chaudhary. Who was the common ancestor?
The पूर्व स्वामी मालिक शिवलाल चौधरी के वारिसान हैं।
Lordship may kindly
यदि
come.
संपत्ति संयुक्त रहती तो उनका how do they acquire the property?
Lordship, Madhusudan Singh Chaudhary was the original land was recorded in Madhusudan Singh Chaudhary. He died leaving behind his three sons, Ruplal Singh Chauhan, Shivlal Singh Chauhan, Sripati Singh Anamoni Devi, and Sripati Singh Chauhan. So it had to be partitioned between three sons, Ruplal Singh Chauhan, Shivlal Singh Chauhan, and Sripati Chaudhary. So Shivlal Singh Chauhan is not the original owner. Original owner is Madhusudan Singh Chauhan, and it has been specifically pleaded by us also. I am from the branch of Sripati Singh Chauhan, the third son. So Shivlal Singh Chauhan is not my ancestor. Read further.
Yes, यदि यह संपत्ति संयुक्त रहती तो उनका भी हक हिस्सा बनता। पढ़िए। और ऐसी परिस्थिति में
यदि ये संपत्ति संयुक्त रहती तो उनका भी हक व हिस्सा बनता और ऐसी परिस्थिति में वे बिक्रीनामा कभी भी हस्ताक्षर कर केवाला निष्पादित न होने देते और हस्ताक्षर से मुकर जाते, किंतु केवालों का इनका हस्ताक्षर हो जाने से यह निश्चय रूप से सिद्ध हो जाता है कि पक्षों के पूर्वजों के बीच हुए बंटवारा में यह प्लॉट नंबर 224 का 8 डिसमिल जमीन पूर्ण रूप से शिवलाल को मिला था, जो कि शिवलाल के मरने पर उनके वारिसों को प्राप्त हुआ। वही कारण था कि बिक्री के समय शिवलाल के भाई रूपलाल का बेटा उसमें गवाह बना और अब कभी आपत्ति नहीं की। इन मौखिक एवं दस्तावेज साक्ष्यों से यह सिद्ध हो जाता है कि तकरारी संपत्ति पर वादी पक्ष का कोई हक का अधिकार नहीं बनता है और न ही उसका कोई हित बनता है। इस प्रकार वह वाद बिंदु संख्या 7
the previous partition is said to be on what basis?
oral partition.
Oral partition. Well, in whose name this property is located?
In the name of Madhusudan Singh Chaudhary.
This property.
This yes.
Is there any exhibit to that effect?
The Lordship may kindly come to page number 35.
Prior to that, you come to the case of defendant number 1 and 2 in para number 3.
The trial proceedings. मामले में प्रतिवादी संख्या 1 व 2 अपना बयान तारीख दिनांक 16/3/1999 को दाखिल करते हुए वादी के कथनों का खंडन किया। उनका कथन है कि वादी पक्ष की जिस तरह से मुकदमा लाया वह चलने योग्य नहीं है। उसके बाद का कोई कारण उत्पन्न नहीं हुआ। उसके बाद विवाद से अधिनियम से बाधित है। इतना ही नहीं, निबंधन मौन स्वीकृति एवं अविभाज्य के सिद्धांत से भी बाधित है। प्रतिवादी पक्ष का कथन है कि यह आवश्यक है कि तकरारी संपत्ति मधुसूदन सिंह चौधरी के नाम से था। उनके मरने के पश्चात उनके वारिसों के बीच आपसी बंटवारा हुआ जिसमें यह संपत्ति शामिल थी और वह प्लॉट नंबर 224 में शामिल थी। वादी पक्ष का कहना है कि यह नियंत्रण सत्य है कि पारिवारिक बंटवारा 224 की संपत्ति छोड़कर कि जबकि सच्चाई यह है कि बंटवारा पूरे संपत्ति का था और यह पारिक बंटवारा में यह प्लॉट नंबर 224 पूर्ण रूप से तथा कुछ अन्य प्लॉटों के सहित शिवलाल सिंह चौहान चौधरी को मिला था। इतना ही नहीं, वादीगणों के पूर्व श्रीपति सिंह ने भी केवाला संख्या 100 के स्वीकार किया है कि मधुसूदन सिंह चौधरी के सभी वारिसों के बीच संपत्ति का बंटवारा हो गया है और श्रीपति सिंह ने इसी केवाला के तहत बलदेव सिंह को प्लॉट नंबर 428 का 27 डिसमिल स्थापित किया। इस प्रकार बंटवारे की बात वादीगण के पूर्व श्रीपति सिंह ने स्पष्ट रूप से स्वीकार कर लिया है। ऐसी स्थिति में वादीगण का यह कहना कि समस्त संपत्ति का बंटवारा नहीं हुआ है गलत हो जाता है। प्रतिवादी पक्ष का आगे कथन है कि उक्त बंटवारे के तहत प्लॉट नंबर 224 की जमीन में से 5 डिसमिल जमीन प्लॉट नंबर 224 का प्रतिवादी संख्या 3 से लगावत 5 ने प्रतिवादी संख्या 2 को केवाला संख्या 16 द्वारा उत्तरी खंड बिक्री किया था और बाद में इसी प्रतिवादी संख्या ने लगाया 5 ने प्लॉट नंबर 224 का दक्षिण खंड 3 डिसमिल केवाला संख्या को प्रतिवादी संख्या 1 को बिक्री किया। इस प्रकार पूरा 8 डिसमिल जमीन की बिक्री प्रतिवादी संख्या 3 लगावत 5 में 1977 में प्रतिवादी संख्या 1 व 2 को कर दिया। उक्त संपत्ति खरीदने के पश्चात उन लोगों ने अपना नाम में चढ़ा दिया और दाखिल खारिज हुआ और उन्हीं लोगों को कब्जा चला आ रहा है। इस प्रकार यह केवल शून्य एवं अवैध है और न ही खारिज होने योग्य है। इतना ही नहीं, यह केवल वादीगण के पिता एवं अन्य हिस्सेदारों की जानकारी में था। चक्रधारी सिंह चौधरी प्रतिवादी संख्या 13 जो कि रुद्रलाल सिंह चौधरी के लड़के हैं तथा इन वादीगण के चचेरे भाई हैं, इस केवल में पहचान
You
करता
have filed a petition under section 87 also. Internal page
Yes,
two,
yes.
just above para 3.
Yes.
You have filed a
Yes.
petition.
It was-
So property was mutated in whose name? That you have
Subsequently, it was mutated
filed. In whose name?
by the purchasers in the name of the purchaser.
So you are objected to mutation in the name of the purchaser, or you are objected to mutation in the name of the this defendant, the ancestor of the defendant?
The purchaser, because the ancestors of the defendant, the property was never mutated. It was mutated in the name of common ancestors, and on the basis of a partition, it was sold to the purchasers.
So I just want to know from you, is there any material to show that the property will continue to stand in the name of the common ancestor?
Yes.
In spite of partition?
Yes, if Lordship may kindly see paragraph number 35.
35.
I will also show the statement.
Para 35 होता है appellate को.
Appellate code. Page
But
page
no-
35, paragraph number 2.
Okay, page 35.
Paragraph number 2.
Yes.
Case of the plaintiff in nutshell is that plot number so and so is provided in last survey settlement Khatiyam recorded in the name of Madhusudan Singh Chaudhary as Awad Malik land. The said land was possessed by him as landlord. After vesting, Madhusudan Singh Chaudhary filed return to the state of Bihar, being case number so and so, which includes plot number 224 also. Madhusudan Singh Chaudhary died leaving behind his 3 sons and daughter, namely Ruplal Singh Chaudhary, Sivlal Singh Chaudhary, Shripati Singh Chaudhary, and Srimati Anumuni Devi. So it was recorded in the name of Madhusudan Singh Chaudhary, and that has not been disputed. They have not pleaded that subsequently after partition it was recorded in their name.
So what is the proposed substantial question of law? Which substantial question of law are you referring to?
Substantial portion of law number F. E and F. First is with respect to presumption of jointness, which is in favor of the plaintiff. So that has
No,
been-
once there is a partial partition, there is a partition, the presumption of jointness will not be there.
So that is my case, madam. The presumption of jointness, that is
Because there is no document showing that there was a partial partition. But you are claiming that there was a partial partition.
they are claiming that.
They are claiming that there was a partial partition, but there is no document as such, right? So there was a partition. So once there is a partition, the presumption of jointness will not be there. You will have to prove, or they will have to prove, whosoever, that this particular property was excluded from the partition. For that purpose, some material has to be brought in.
So the other substantial question of law is with respect to the court's reliance upon a registered sale deed which was under challenge. So that is E and F.
The court has relied upon the sale deed executed by the plaintiff,
By the defendant.
no, by the plaintiff also. By the plaintiff also. They have relied upon a sale deed executed by the plaintiff also.
The plaintiff, the sale deed has not been executed.
Yes, I saw it somewhere. 1972. Sale deed number 16741 dated 12/6/1972.
That is with respect to a different plot.
Maybe it is with respect to a different plot. स्वीकार किया है कि मधुसूदन सिंह चौधरी के सभी वारिसानों के बीच संपत्ति का बंटवारा हो गया था और श्रीपत सिंह ने इसी केवाला के तहत बलदेव सिंह को प्लॉट नंबर 428 का 27 डिसमिल स्थानांतरित किया। इस प्रकार बंटवारा की बात बालीगंज के पूर्वज श्रीपति सिंह ने स्पष्ट रूप से स्वीकार किया है। ऐसी स्थिति में बालीगंज का ये कहना कि समस्त संपत्ति का बंटवारा नहीं हुआ है सो गलत है। So, what is it from the record? The property, what is the finding as to in whose name the property was running? You have stated that it was recorded in the name of Madhusudan,
Yes.
right? Then some petition under section 87 was also filed. So I just want to know that what was your objection? Was it recorded in the name of the ancestor of the defendant to which you filed section 87 petition? Or you filed section 87 petition with regard to the purchasers of the suit property? If it has been recorded in the name of the ancestor of the defendant,
I have no case.
then you have no case. Simple.
But that was not my point of objection. Section 87 was filed with respect to.
We do not know what was from where do I get at what time. What is the evidence regarding section 87? There is no material brought on record regarding 87. Where is the list of exhibits? And where is the oral evidence? What led you to file section 87 petition?
You will find the list of evidence at page number 8.
You just see page number 23. This your 87 petition was dismissed?
Yes, ma'am. It was.
Yes, it was dismissed. It was mutated. You objected to this. There is a presumption regarding the validity, correctness of section 87.
Yes, yes. But it has
And once there is a partition, there is no question of any presumption of jointness.
It has section 87 judgment will have a force of degree. But my case is that even if that section 87 order is against me, my suit for declaration is
So
not.
that's
barred.
right. It is not barred. We'll deal with the presumption
Yes.
under section 87.
Also, if the safety is under, there are two things. I can always file a suit for declaration, and I can also file a suit challenging the registered safety on the basis of which the property has been mutated.
That's right. But your entire challenge is that it is a joint family property.
Yes.
The crux of your challenge is it's a joint family property. नहीं चलेगा लड़का.
So,
नहीं.
section 87 order. That I could
Second appeal number 498 of 2017. Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 8/8/2017, within bracket, decree signed on 21/8/2017, bracket close, passed by the learned district judge Roman 15, Dhanbad, entitled appeal number 44 of 2013, whereby the appeal preferred by the appellants has been dismissed and the judgment dated 18/3/2013, decree signed on 22/3/2013, passed by the learned civil judge within bracket senior division dash Roman 5 Dhanbad in partition suit number 107 of 1997 has been affirmed. The learned trial court had dismissed the suit. The suit was dismissed. The first appeal was also dismissed, and the plaintiff is the appellant before this court. The learned counsel for the appellant has submitted that both the learned courts have failed to consider that there is presumption of jointness with respect to joint family property, with respect to joint family. He has also submitted that the plaintiff had sought partition with respect to plot number 224, area 8 decimal. By asserting that the same property is the joint and idmal property of Madhusudan Singh Chaudhary, which was never partitioned by mix and bond among the co-sharers of years of late Madhusudan Singh Chaudhary. It submits that other plots were partitioned, but this property was not partitioned, and therefore the plaintiffs were entitled to 1/4 share in the plot. The learned counsel submits that the defendant number 3 to 5 had executed same deed in favor of defendant number 1 to 2, while same deed number 450 and 451 dated 25/1/1977, and the same deed was also challenged in the suit. '77 का same deed आप 97 में चलेंगे? Limitation का क्या finding?
Limitation ground they have not taken. No issue was all. They have not taken any ground there. No issue.
And the
was
court
also.
has also not taken care of that. Very good. Then part limitation का issue है Roman 3. और प्रेस करके छोड़ दिया. The learned counsel has submitted that both the courts have not considered these aspects of the matter, and accordingly, substantial question of law be framed and decided. After hearing the learned counsel for the appellant, this court finds that the suit was filed for the following relief. Para 5 में appellate court judgment का. The specific case of the plaintiff was that plot number 224 was recorded in the name of Madhusudan Singh Chaudhary, and the said land was possessed by him as landlord. And after vesting, he filed return to the state of Bihar. Included plot number 224. He died leaving behind his 3 sons and a daughter, namely Ruplal Singh Chaudhary, Shivlal Singh Chaudhary, Shripati Singh Chaudhary, and Srimati Amomani Devi. Ruplal Singh died leaving behind his 2 sons, Chakradhar Singh Chaudhary and Balram Singh Chaudhary, and 3 daughters, namely Sharma Devi, Srimati Nishoda Devi, and Saraswati Devi. Nishoda Devi also died leaving behind 2 sons, namely Sanjay Kumar Rai, Rajiv Kumar Rai, and 2 daughters, Beena Devi and Srimati Baby Devi. Further, Shivlal Singh Chaudhary died leaving behind his widow Shushila Divya and 2 sons, Kailash Prasad Singh and Kashinath Singh, as well as 4 daughters, Pratima Devi, Kamla Devi, Megha Devi, and Champa Devi. Shripati Singh also died leaving behind his widow Yashoda Devi and sons namely Tripurari Devi, Pavan Kumar Chaudhary, Guruveshwar Chaudhary, Ganesh Singh, and Bashish Singh Chaudhary, and a daughter Kalavati Devi. The legal heirs of Shripati Singh Chaudhary are the plaintiffs of the case. It was the specific case of the plaintiff that the said property was joint property and was never partitioned by meets and bound. So far as other plots are concerned, there has been partition. तो मेंशन भी नहीं किया था हम लोग को मेंशन नहीं किया तो हम लोग क्या कर सकते हैं अब आइटम 37 को भी टेकअप हो जाएगा And accordingly, it was a case of the plaintiff that they are entitled to share 1/4 share of the property. It was also pleaded that the sale deed executed by defendant number 3 to 5 in favor of defendant number 1 and 2, transferring the entire plot number 224 is a void document. The learned trial court, the defendants admitted the fact that Madhusudan Chaudhary was a tenure holder in with respect to plot number 224, but denied that 224 was joint property. It was also stated that after death of Madhusudan Chaudhary, the heirs amicably made oral partition in the 1967, and plot number 224 was also included, which came in the share of Shivlal Singh Chaudhary. It was denied that except plot number 224, all other plots were partitioned. It was also asserted that the father of the plaintiffs, Shripati Singh Chaudhary, himself had executed a registered sale deed dated 12/6/72 in favor of Baldev Singh Chaudhary, transferring 27 dismissal of plot number 428. It it was stated that Shivlal Singh Chaudhary sold 5 dismil of land out of plot number 224 by registered sale deed on 25/1/1977, and then defendant number 2 transferred 5 dismil of land to defendant number 2 and 3 dismil of land to defendant number 1, while 2 registered sale deeds dated 25/1/77, and since then defendant number 1 and 2 were in possession of the entire 8 dismil of plot number 228. And in the recent survey settlement, the plot number 228, new plot number 208 stood recorded in the name of defendant number 1 and 2, and they have been paying rent of plot number 224. The trial court framed the following issues for consideration. The trial court, after considering the materials on record, has, from the perusal of the judgment passed by the learned trial court, it further appears that a petition under section 87 of Totonaku Tenancy Act was also filed by the plaintiffs, which was pending. However, while deciding the issue number 7, the learned trial court ultimately decided issue number 7 and considered the materials, after considering the materials on record, and held that the plaintiffs do not have any right, title and interest over the suit property. And it was not a joint family property. While deciding the issue number 1, 2, 3, 4, 5 and 9, the learned trial court also recorded that the oral and documentary evidences revealed that the entire property was partitioned, and the evidence of the plaintiffs was also taken into consideration. Oral evidence of the plaintiffs were also taken into consideration, and came to a finding that they also deposed that after the partition, the respective parties took possession of their individual shares. The learned court recorded that under such circumstances there was no question of any partition again. It was also brought on record it was also submitted by the defendants that the petition under section 87 of CNT Act was also dismissed. The learned first appellate court the learned court, the learned first appellate court framed the point of determination in paragraph 15 as to whether there is unity of title or unity of possession of the parties with respect to the suit land, and secondly, whether the plea of previous partition as alleged by the defendant number 1 to 5 is true. The learned first appellate court recorded that under Hindu law in para 18, the 18 and 19, that in view of the fact that severance of joint family was accepted by the plaintiff, it was for the plaintiff to prove that so far as plot number 24 is concerned, the same was still a joint property. The learned court also considered the evidences of the plaintiff and has also recorded that it was an admitted fact that in recent survey operation, the disputed plot was recorded in the name of defendant number 1 and 2, and it was an admitted fact that the challenge to that entry was made, but the same was dismissed as withdrawn. The learned court ultimately recorded that there was that nowhere in the entire trial of the suit it was even suggested as to why plot number 2 to 4 was not partitioned. No documentary evidence was brought on record to suggest that the plaintiff were in possession of 1/4 area of the disputed land. On the other hand, the defendants brought on record two series, Exhibit B and B by 1, numbered 450 and 451, both dated 25/177, which go to show that the defendant number 1 and 2 had purchased the entire plot number 2 to 4 of Khata number 58 from the defendant number 4 and 5, and they were in possession of the suit property. The learned court also considered that there was no doubt that there was previous partition amongst the co-sharers about 30 years before, and now it was impermissible to raise the issue that such plot was not partitioned. The learned first appellate court ultimately dismissed the appeal. This court finds that there are concurrent findings. This court is of the view that there are concurrent findings of both the courts with regard to previous partition, and the property also stood mutated, recorded in the name of defendant number 1 and 2, who were found in possession of the property. And the plaintiff could not bring on record any material to show that plot number 2 to 4 was not included, as it appears was excluded at the time of partition. This court finds that both the learned courts have passed reasoned judgment taking into consideration every aspect of the matter. There is no substantial question of law, involved in the present case, the learned counsel for the appellant has not been able to show any, has not been able to show any perversity in the matter of appreciation of evidence by both the courts. Next.
लॉर्डशिप वन क्वेश्चन सीन नंबर 40 लॉर्डशिप वो मैं गिर गई थी गाउन पर गाउन में फंस के मैं गिर गई थी .8 इसमें टाइम से 41 कॉल
चलिए
Item 42, second appeal 306 of 2018.
काइंडली लॉर्डशिप डेट ही हो गया 40 सीरियल नंबर
5 बार आपका केस
नहीं
एडजर्न
मैं गिर गई इसलिए वो उठाने लगे वो उसी में टाइम लग गया नहीं पता मैं टाइम से एकदम पहुंच गया
देखिए रिकॉर्डेड प्रोसीडिंग है ना हम इस तरह से नहीं कर सकते You have some responsibility and you should also have some
इस सॉर्ट से
responsibility.
मैं मानती हूँ अपनी गलती
कोई बात नहीं आप रेस्टोरेशन राइट है इसका कुछ हो नहीं सकता 2017 से अभी तक सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं बनवाई
इसमें जो डाई हो गया सिर्फ इतना ही पता
We do not know. चलिए कौन Yes please.
Lord, it is plaintiff second appeal. Suit was filed to worship for cancellation of said deed. My lord, the ground your worship was that my lord, initially my lord, the suit property was recorded in the name of Dillo, Rope and Hero. And my lord, in the revisional survey records of the issue. My lord, other sons of the Dilogo, their name were also included. And on the basis of that, they sold out the property to defendant number 1. One Babun Mato had not sold the property. He is also
There is a caveat also
my
for substantial question of
Yes.
law we
The
don't
point
know.
of law, your lordship, for fine consideration, your lordship. My lord,
Let us see the relief rate.
they want, my lord, they are saying that, my lord, if there was a partition.
77 said it challenged in 2006.
Yes, but
What is the
we have,
finding
we
on
have, we have a
limitation?
cause of action because
What is the finding on limitation?
limitation the court is saying, but that finding is perverse as because, my lord, in the year 2006, when they, my lord, filed an,
Who is in possession?
I am in possession. I'm in possession. And my lord, they have only brought rent receipts, my lord. They claim that they have purchased the property way back in 1977. But my lord, only 3 or 4 rent receipts they have produced on record.
It is an admitted case that there was a transfer because you have challenged the sale deed.
I
The
agree
moment
with
you
that.
challenge the sale deed,
I agree.
it stands admitted.
But my lord,
And since you were challenging the sale deed, you were supposed to bring it on record.
my lord, may kindly appreciate. They are saying that there is a partition in the field. That is what they understand. And after the partition, your lordship, the shareholders has transferred to them. Now the, my lord, the onus of proof, your lordship, is not on the plaintiff. It is not in dispute. It is not in dispute that this is a property. My lord.
Please first satisfy me on the point of limitation.
Yes.
If a suit is barred, I think this is 77D, you are challenging in 2006.
Yes.
How many years have elapsed?
My lord, definitely more than, my lord, 30 years.
More than 30 years. Explain the limitation.
But, my lord, may
And what is the finding on the limitation? But ये कहाँ है issue number?
हम बता रहे हैं.
It is barred by limitation.
हाँ, बता रहे हैं. Whether the suit is barred by law of limitation and adverse condition. There is no ingredient for adverse condition. No, nothing treated, nothing.
You challenge the sale deed after 30 years, kindly
My
explain.
lord, your lordship, may kindly appreciate. There is no bar in the law that one cannot challenge the said deed, my lord. The limitation point starts, my lord, when the persons came to know about it.
What is your date of knowledge?
My date
As per
of
your
knowledge is
case.
2006.
As per your case, what is your date of knowledge?
2006.
And what is the mode and manner of date of knowledge?
Yes, what happened, Your Lordship? That they had purchased, they claimed that they had purchased the property way back in 1977. But in the year 2003 and 4, those rent receipts they have brought on record. In the year 2006, when a 144 proceeding was instituted, then when they filed this proceeding, in the so-called we came for the first time, that is what is our standing. That is what is our standing. 2003-4, Your Lordship, only those credits, only those rent receipts they have brought on record. Admittedly, prior to 2004-6, there is no rent receipts also on record. And the learned judge, Your Lordship, had presumed the possession also. It is not in dispute, Your Lordship. It is not in dispute. That the land belongs to Dilo Gop and the Nero Gop, Your Lordship. And the persons through whom they are claiming, they are the sons of the Dilo Gop. It is not in dispute. So far as this property, Your Lordship, is concerned, our case, Your Lordship, is that by way of Hukumnama, way back in 1935, Your Lordship, the property was acquired by this Nero Gop and Dilo Gop, and thereafter, their name were recorded. I have brought on record, Your Lordship, the rent receipts, etc. also. But the learned court had discarded it on the ground that you have not brought any rent receipt, that too after the exclusion of the city.
You are the descendants of Dilo Gop or Nilo Gop?
I am the descendants of Dilo. May kindly see the genealogy.
You show me the finding on the point of
I would like to show first the genealogy, which is the part of the judgment itself.
Genealogy is not in dispute. Let's not digress. If a suit is barred by limitation, full stop. So you satisfy me on the point of limitation.
My Lord, may kindly see the findings on the limitation. Your Lordship, it is issue number, my Lord, 4. Issue number 4, my Lord, main issue of law, it is taken up for the consideration. Then, my Lord, may kindly see the last part here. Several things he has considered. I also found that I am reading it in the middle, page 20, internal page 20. Last page.
You just read it from page number 18,
Madam.
bottom. Page number 18, bottom.
Or number 18.
Bottom. On the above discussions, I find.
On the above discussion, I find that it is admitted fact that joint property, that the suit property was acquired by Nilo and Dilo Gop and Buri Gop, son of Moar Gop jointly. It is also admitted that old Khata 1 of 49 converted into new Khata, and the old plot is converted into new one, plot number 3.02 acres. It is also pleaded by plaintiff in title suit 41. One title suit, Your Lordship, was earlier filed that was allowed to be withdrawn. That the father of the Nilo Gop, namely Dilo Gop and Dodi Gop, cutting the bush and the shrub over the suit land. Then it was settled in the name of the Dodi Gop, son of Mohar Gop, and the Nilo Gop and Dilo Gop. It presumes
that
it presumes. But at the time of acquisition of suit land, the family of Dilo Gop and Dodi Gop was joined. The plaintiff himself has stated in the pleading of 40 that the Dilo Gop and Dodi Gop partitioned the suit land half and half in the lifetime. But in this suit, plaintiff contradicted his version and pleaded the family of plaintiff and for former defendant is still joint, and the suit land is also still joint. So plaintiff is stopped to contradict the version of previously stated in his pleading, section 115 of the Evidence Act. The recital of the sale deed filed by the defendant also proved this fact that the partition was made by the family arrangement in the between the ancestor of the plaintiff and profound former defendant for the suit property. Khatyan of RS proved this fact that the record of right was prepared in the name of the defendant of Dodigo and Dilogo, but in place of half share in the suit property, that the share of the defendant of Dodigo was recorded as 1/3 share, but it was not objected within 12 years after the separation of records of right. In his pleading that he has no knowledge
Plaintiff stated
about
in
the
his
injury.
pleading that
His ancestor has no knowledge.
that he and his ancestors had
Has
no
no
knowledge.
knowledge about the entry of the revenue records of rights, but he did not disclose that when he got knowledge about this entry of the RS. It makes presumption against the plaintiff that he and his ancestors have full knowledge about the entry of record of rights, that the entry was not challenged by him within 12 years from the publication of records of right. So after lapse of 12 years, the challenging the entry of records of right is barred by law of limitation. I am not challenging the entry.
That's right.
Please, unable to file rent receipt after 1960 about the share of Dodi in the suit property in the name of the defendant of the Dodi Go after abolition of Zamindari. He has also not pleaded in his pleading that when rent receipt has not been issued for the property for half share of the Dodi Go, then why he did not make the objection before the predecessor prescribed authority for issuing the rent receipt for his half share in the name of the defendant of Dodigo. This makes presumption that the plaintiff admitted the entry of RS survey possession of Dilogo, Sivago over lands. Accordingly, the recorded share of the descendants of Dilo, Siva, Dodi recorded. It is also proved that Nero died after 1982 because the sale deed was executed by Nero Gop in the name of Ladhari and Bulas Mahto. Jharkhand and one of the plaintiff along with title suit. He also found that mutation of the property was done in the year 1970, 78, but plaintiff did not make any objection in the mutation case and also not filed any appeal under mutation order. But no such order or anything has been brought on record, except the certain receipts, which is of year 4 to 2004-434. Continuous rent receipts about the suit property after purchasing the same by contesting defendant and oral evidence of defendant prove the possession of money. There is no continuous rent receipt. That is a perverse content. I find that the plaintiff was full knowledge of the deed of the defendant, but he did not file any suit for cancellation within 3 years of its execution. I also find that they are in continuous possession over the suit land within the knowledge of the plaintiff and ancestor from the execution of the so the contesting defendant perfected his right title on the basis of adverse possession also. They are taking contradictory plea. First of all, they are saying that they have got title by virtue of sale deed, and now without any ingredient of adverse possession, the court has actually declared their title by that they acquired by adverse possession. This is what is the finding on the position on the limitation. Then, issue number 5. This is one of the main issue of law in his pleading that the plaintiff previously filing title suit is barred order 202. But on this point, after going through this issue of order suit, the plaintiff of title suit number 40 of 2004, I find that the plaintiff filed the suit after same property, same cause of action and same relief, and this suit was withdrawn by the plaintiff. Original record also called for. After perusal of plaintiff for withdrawal, I find and held that this suit was filed by the plaintiff to withdraw the suit with liberty to file fresh suit. And this petition was allowed by the court by order dated so and so. I find and held that the suit is not barred by order 2, rule 2 CPC. This issue is decided in the favor. So on above discussion, I find plaintiff suit is barred of the limitation. So virtually there is no discussion as such.
No, the discussion is there in by deciding issue number 4. The court also says that this has been decided by deciding issue number 4.
The issue number 4, they are only saying that I had knowledge about the records.
That is enough.
The question that is not, my lord, may kindly appreciate.
That is enough.
That is not.
You challenge a sale after 30 years,
My lord, may kindly appreciate.
and then you say that this
Records-
finding is irrelevant.
had it been a case of records of rights, then my lord, I would have said that it is not within 12 years, or my lord, it is something that the matter.
No. They say that the suit also has not been filed within 3 years from the execution
No,
of the
what I am
deed,
saying.
in spite of knowledge.
No, my lord, may kindly appreciate that our specific, my lord, pleading, your lordship, that, my lord, only after filing of the 144 proceeding, your lordship, when they filed the so-called, my lord, they my lord, we came to know about the sale. Those things have not been discussed at all.
That's right.
My lord, may kindly appreciate it. The date of knowledge, your lordship, is the relevant date, my lord, on which a person gets a cause of action. My lord, sale date may be of 80 years old, but the question is that whether the same was in my knowledge or not, that is the point to be considered. My lord, I may have a knowledge of, my lord, records of rights. I may have a knowledge, my lord, that the certain person's name has been illegally entered. I may not have challenged the records of rights. Those things are a separate issue. My suit, your lordship, is with respect to, my lord, the cancellation of the sale. For that, my lord, the requirement in law, your lordship, is whether I had a knowledge of those sale deeds or not. My specific pleading, your lordship, is that I had a knowledge in the year 2006. Then, my lord, nowhere, my lord, the court has discussed, so far as the trial court is concerned.
You say that you gained knowledge for the first time in 2003.
2006.
2003.
6.
3.
I have a copy of it.
Check.
What is my pleading I am saying? Vendors had not sold the joint property, hence the sale deed of dependents are void, inoperative and not acted upon today. Hence the whole sale deed are forced, fabricated, inoperative, the dependents have no right, interest, cultivating possession, purchased in connection with the sale deed, within which they fully describe the schedule. Plaintiff has his brick bhata in khata number 32, note number 664, 665, 20. Plaintiff obtained certified copy of the sale deed from 6/1/2003 to 2/8/2004. Hence, the cause of action arose 6/1/2003 and day to day within the jurisdiction of. Even if this date is considered, the suit was filed in the year 2006.
That's all.
इसमें ये हम कहना चाहते हैं
केस में होता है तो बना देते हैं।
नहीं, हम 1 मिनट हम इसमें कहना चाहते हैं कि पार्टीशन का जो कि इनका जो क्लेम है कि आपका पार्टीशन हो चुका है, कोई पार्टीशन का बिना डीड लाए हुए कोर्ट कैसे प्रिज्यूम कर सकता है? हाउ कैन द कोर्ट प्रिज्यूम?
Is there any bar in the oral partition?
Yeah. No. Oral partition there is no bar. There are recital to that effect also. That in the sum of the sale deeds there are recital also. घर मौजवाई बंटवारा. लेकिन those are not of conclusive equivalence. That is one point. Second point I want to say. अगर मान भी लें कि ये डीड सही, सेल डीड अगर ये सही, तो भी अपना शेयर के बियॉन्ड तो नहीं ना करेंगे. वो पॉइंट भी बहस हुआ था, उसको भी कोर्ट ने भी उसको भी अप्रिशिएट नहीं किया. अगर मान लें कोई आदमी अगर सेल डीड डिस्प्यूट किया, ठीक है, I agree to that. But can a person execute a sale deed beyond his share? अगर तीनों का भी शेयर माना जाए तो 1.2/3 से ज्यादा एक पार्टी को नहीं होगा और इन्होंने मोर देन शेयर अपना जो है सो इसको बेच दिया। इस पॉइंट पे हमारा इसमें पॉइंट ऑफ लॉ डिफरेंट है। इस पॉइंट पर भी इसको हजूर विचार किया जा सकता है। इसमें मेरा क्वेश्चन ऑफ लॉ देखा जाए। अगर सेलिंग मानते हैं सही भी है तो कम से कम उसका डिस्कशन हमको अपीलेट कोर्ट का दिखा देते हैं।
अब ऑर्डर सुनो।
जी मतलब एक बार जस्ट फॉर
लोगों को शांति से जीने
substantial question of law page number 8. Whether the observation and finding of the learned court to the extent that the suit was hit by estoppel is permitted as essential ingredient to attract full of elements.
स्टॉपल का कहाँ कुछ फाइंडिंग?
एक नाम आप दिखा
सब स्टॉपल से कोई लेना है?
एस्टॉपल पर भी जजमेंट किए हैं।
जब मन होगा अपना डेटा ऑफ नॉलेज डाल के जो है सेलिंग चैलेंज कर लीजिए।
For that, the learned court will have failed to consider that the descendants of Nero group had no right to sell more than their share, which means that they had right to sell only 0.25 decimal of land, but by the impugned credits, more than the area has been transferred, which is illegal. I'm putting a question to myself. Can a person sell the property more than his share? I agree to that proposition, Your Lordship. May I hold this credit as correct? I have nothing to say. But Your Lordship, may kindly appreciate, my lord, that they have sold the property beyond their share. Even as per the revisional survey records of rights, my lord. Even as per the revisional survey records of rights, if the three parties, Your Lordship, is having 1/3 share, then, my lord, how the property can be sold more than the 1/3 share? This is the point of law, Your Lordship, which I would like to advance, Your Lordship. That was taken up by the appellate court, Your Lordship, but has not been, my lord, taken care only on the because, my lord, out of the old khata plot, my lord, only 11 plots, my lord, have been, my lord, carved out, my lord. But, my lord, the learned appellate court, Your Lordship, has taken into consideration that there are altogether, my lord, 18 plots. But, my lord, in the earlier survey records of rights, my lord, there were certain other plots included. But, my lord, both parties have agreed that there are only 11 plots, my lord, which are under dispute, my lord, which are only disputes. So, my lord, this issue, Your Lordship, the learned appellate court has not properly considered. I am only saying, my lord, that the sale deed to the extent, my lord, beyond their sale, Your Lordship, that cannot be allowed. At least that part, Your Lordship, is required to be considered. That finding, Your Lordship, may kindly see, my lord, the appellate court finding. My lord, may kindly see page 20 of the appellate court judgment, para 17. So far as the other ground, vendors had not sold the joint family property is concerned, the plaintiff has not pleaded that the vendor has sold the joint property beyond his share, rather he has simply pleaded that para 19, the vendors has not sold the joint property, hence the sale deed of the defendants are void, inoperative and not acted upon. To prove this pleading, plaintiff has not examined vendor and his legal heir to establish the fact has not sold the land. At the time of argument, the learned counsel argued that the total area of 32 is 3 acres 2 decimal. If 3.02 acres are divided in 3 parts, as per the Khatiyan, the one shareholder will get 1 by 2 upon 3. Hence, one shareholder has only right to sell 1 upon 2 upon 3, but the Nirogov has sold 1.404 acres by virtue of setting 7168 and dated 10-10-1977. He further argued that the Leko Rupan Babun Dharam has right to sell only 1.04 acres. They should have sold only 0.75 decimals out of 1.213, and the sale deeds are in question are fit to be cancelled and declared null and void. Therefore, learned counsel for the plaintiff indirectly argued that the vendors had sold the land beyond their share. But plaintiff has not pleaded such type of pleading in his plaint, although from the perusal of records of right it appears that Khata number 32 total is 5.32 acres as per dismissal. As per the pleading of the plaintiff, Khata 32 divided in 11 plots, but records of right clearly shows to prove that the land of the Khata 32 is divided in 18 plots. That is not correct. My lord, in the earlier CS records of right, apart from my lord, the plot in question, there were some other plots were also included. And both the parties, your lordship, has accepted that it is only 11 plots which is in question, which has been carved out from the earlier CS plot. So, my lord, only taking into consideration that, my lord, there are 18 plots. The court has presumed that one can sell more than 1.23. That finding itself is also, my lord, is a barbarous finding. My lord, it is well settled principle of law that a person cannot sell, my lord, his share beyond his share. These sale deeds, your lordship, may be declared as my lord, the valid and genuine. But, my lord, to the extent, my lord, to that the shareholders have not the right. Beyond that, it is already void. It is already void.
Second appeal number 306 of 2018. Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 28/4/2018, within bracket decree dated 11/5/2018, passed in civil within bracket title, appeal number 29 of 2008, whereby the appeal has been dismissed. The trial court judgment has been passed by judgment dated 27/5/2008, within bracket decree dated 7/6/2008, in title suit number 18 of 2006. Whereby the suit was dismissed. Consequently, the plaintiff is the appellant before this court. The learned counsel for the appellant, by assailing both the judgments, has submitted that the trial court as well as the first appellate court have held that the suit was barred by limitation he has submitted that the sale deeds were challenged as soon as the plaintiff had knowledge about the sale deeds. Plaintiff had knowledge about the sale deed, and the plaintiff came to know about the sale deed for the first time on 6/1/2003. And then he filed title suit number
18 of 2006.
Then he filed title suit number 40 of 2004.
It was much earlier.
40 of 2004 आप फाइल किए ना, उसके बाद इसको विड्रॉ करके फिर फाइल।
ये वाला
Correct?
2006.
40 of 2004, and the said suit was withdrawn, and ultimately the present suit bearing title suit number
18 of 2006.
18 of 2006 was
With
filed.
liberty was filed.
He submits that liberty was granted to file the suit, file the fresh suit. The learned counsel has submitted that the material date is the date of knowledge of the sentence, and this aspect of the matter has not been properly considered by both the courts, by holding that the suit challenging the sale deeds was barred by limitation. The learned counsel has further submitted that even if the sale deeds are held to be, even if the challenge to sale deed are held to be barred by limitation, then also the defendants could not have sold the property in excess of their share. And this aspect of the matter has also not been considered. That's all.
That has been considered, but
Not properly considered.
appellate court has not properly considered.
Has not properly considered. After hearing the counsel for the party, for the appellant, this court finds that title suit number 18 of 2006 was filed by the plaintiff against the contesting defendant number 123, seeking cancellation of sale deed number 7168 dated 10/177, sale deed number 7759 dated 7/177, and sale deed number 7768 dated 7/1/1977, which was executed in favor of the defendants. वेंडर को पार्टी नहीं बनाए थे, वेंडर को
Vendors, some of the vendors are parties.
in favor of the defendants कैसे?
1 to 3 के favor में. Other are some others are other shareholders. They filed the contesting written statement in my favor, but have not deposed. That has been taken. Adverse inference has been taken against the plaintiff. But they have supported
In favor of the defendants.
defendant 1 to 3. So stated by
पता नहीं
this
चल रहा है, ट्रायल कोर्ट में खाली डिफेंडेंट्स लिखा हुआ है।
नहीं,
ट्रायल कोर्ट
1
का
to 3.
डिग्री है,
1 to 3.
ट्रायल कोर्ट का डिग्री है।
Defendant number 1 to 3.
The learned counsel has submitted that the sale deeds were executed in favor of defendant number 1, 2 and 3.
One to 3. 3 to 4 to 10 are my parties, who are the other shareholders of Sons and
What
Sons
about
of-
the vendor? वेंडर को नहीं पार्टी बनाइएगा।
उसका तो डेथ हो गया है, नीरो का डेथ हो गया है, लेखो बाबू ये सब वेंडर हैं।
देखिए, the
4 और 5 वेंडर हैं
Mr.
और धर्म हैं, उनके लड़के लोग।
The case of the plaintiff was Dodi Gop, son of Mohan Gop, along with sons of Dido Gop, the case of the plaintiff was that the manager of Ramgarh Ward estate settled the land in CS Khata number 1/14, plot number 388, 156 and 115, area 5.32 acres, in the name of Dodi Gop, son of Mohar Gop and Nilo Gop, son of Dilo Gop, by way of Hukumnama, dated 3/9/1935, and they came in possession of the property, and their name was entered in Jamabandi register of Hazaribagh estate. And after abolition of Jamabandi, the government also confirmed their possession and their receipts were issued in their name. It was the further case that during the survey new plot numbers were carved out, but it was wrongly recorded in RS record of rights in the name of Nero and Dilo, 1 Ansh, and Lekho, Rupan, Babu and Dharam, 1 Ansh. It was their case that the entry in record of rights was not within the knowledge of the descendants of Dodi and Dilo. However, the descendants of Dodi and Niroko came in joint cultivating possession over the land of old Khata number 1/49 and new Khata number 32. Further case of the plaintiff was that plaintiff Lakhan Gop was the Karta of joint family of deceased Mohar Gop, and the plaintiff had filed a case and the defendant had filed a case number 95/03 under section 144 CRPC in the court of SDM Kodarma, in which notice was issued, and then the plaintiff first time came to know about the fact that Nero Gop had executed a SAD number 7168 dated 10/10/1977 in favor of Bhagwat Thakur and others for 1.04 acres of land of Khata number 32, and Lekho, Baboon and Dharam had executed SAD number 7759 about 0.19 decimal of plot number 686 Khata number 32 in favor of Bhagwat Thakur and others, and Lekho, Babu and Dharam also executed SAD number 7760 with respect to plot number 663 area 0.30 decimal in plot number 590 area 29 decimal and plot number 599 area 26 decimal, total 0.85 decimal in favor of Dharam Hajam. Nero Gop died in 1972. It was a case of the plaintiff that Nero Gop had expired in 1972. Therefore, there was no question of executing sale deed number 7168 dated 10/10/1977 in favor of Jharkhand. It was the further case of the plaintiff that the vendors of the sale deed had no right to sell the joint family property in favor of the defendants, and that the sale deeds were never acted upon till the date of filing of the suit, and the deeds are void, inoperative, forged and fabricated. And the defendants have no right, title and interest and possession over the purchased land arising out of the sale deeds. As per the plaintiff, the cause of action arose when they obtained the certified copy of the sale deeds on 6/1/2003 and 2/8/2004. Defendant number, as is apparent from the trial court judgment, defendant number 4 to 10 were pro forma defendants who had filed their written statement admitting the case of the plaintiffs. The contesting defendants were defendant number 1 to 3, who filed their written statement stating that the suit was not maintainable and the plaintiff did not have any valid cause of action, and the suit was also barred by limitation and adverse possession. It was also barred for non-joinder and misjoinder of necessary party because the recorded tenant Bhupat Gop, Lato Gop, Pandan Gop or their descendants were not party in the suit. It was asserted that the recorded tenant Niro Gop also died, leaving behind his two sons, Jhama Gop and Nanu Gop, and a daughter, Parva Devi, but all the descendants of Niro Gop were not made party in the suit. Likewise, the recorded tenant Rupan Gop died, leaving behind his widow, but she was also not made party in it. Thus, all the descendants of the recorded tenants were necessary party in the suit. It was also asserted by the defendants that initially the suit, title suit number 40 of 2004 was filed against the same defendants with respect to the same property and the same cause of action and for the same relief, and the suit was withdrawn by the plaintiff without any permission to file fresh suit, and therefore the suit was hit by Order 2, Rule 2 of CPC. So far as the merits of the case is concerned, the defendants admitted the fact that the recorded tenant Dilogo died, leaving behind his sons Nirogo, Shivago, and daughters Sugya and Sobhya. The defendants denied the fact that there was unity of title and of possession between the descendants of Nirogop and Dodigo with respect to the land of Khata number 32, and also asserted that the statement of the plaintiff is self-contradictory inasmuch as is self-contradictory to the statement made in the pleadings of title suit number 40 of 2004 that the name of Dilogo and Dodigo was recorded but self-contradictory with respect to pleading in title suit number 40 of 2004. It was also indicated, it was also asserted that the plaintiff in his pleading in title suit number 40 of 2004 stated that Dilogo and Dodigo had partitioned the land of the suit Khata number 1/49 in their lifetime by meets and bounds, and each got half and half share in each plot. But in this suit, the plaintiff has made self-contradictory statement and stated that there was unity of title and possession with respect to the suit land amongst the descendants of Dilogo and Dodigo. It was also asserted by the defendants that the suit land was partitioned by leaps and bound, and the parties were exclusive possession was granted, and ultimately the sale deeds were executed and the purchasers were put in possession of the property, and they were in peaceful continuous possession. And the property was also mutated in their name, and they were paying rent to the state government within the knowledge of the plaintiffs. The defendants also claimed adverse and hostile possession from the date of execution of the sale deed number 7760 dated 7/11/1977. It was asserted that the sale deed was executed and registered within the full knowledge of the plaintiffs and their ancestors, and the plaintiff and the pro forma defendant number 426 have no right and possession over the suit lands. It was also asserted that reliance was also placed on the recitals of the sale deed. The defendants denied the fact that Nero Go died in the year 1972, but asserted that he died in the year 1985, and he had executed the sale deed number 2617 dated 26/2/1982 with respect to Khata number 31, area 1.51 acre in favor of sons of plaintiff number 1. Of title suit number 40 of 2004, namely Jharkhand Mehto. And the sons of Jharkhand Mehto also came in possession of the purchased land. It was asserted that, which falsifies the statement of the plaintiff that Nero Hope died in the year 1973 before the execution of the sale deed number 7168 dated 10/1977. It was also asserted by the defendants that after partition, the plaintiffs also came in exclusive possession of their share, and they also sold the property wide registered sale deed number 3485 dated 12/2/1975 in favor of Samali Devi and Prema Devi, and they were put in possession of the property. They have also mutated the property in their name and have been paying the rent regularly to the state. The plaintiff did not make party to the aforesaid purchaser, namely Samri Devi and Prema Devi, in this suit. Defendants further refer to the other sale deeds. Another sale deed number 7759 dated 7/11/1977 and again asserted that the sale deed was executed after full knowledge of the plaintiff and mutation was also done. The defendants denied the existence of joint family. They also denied that the plaintiff had no knowledge about the sale deeds in question and that they came to know about the sale deeds for the first time in the proceeding under section 144 CRPC. They further stated that the sale deeds were valid and acted upon and they were in possession of the property. The suit was barred by litigation. The following issues were framed by the learned High Court. Both the parties adduced oral and documentary evidences. The learned trial court considered the issue number 4 by paragraph 9 and after considering the materials on record including the various mutation orders and also the fact that the plaintiff had pleaded in title suit number 40 of 2004 that the suit property was partitioned by meets and bound in between the recorded riots Nehru and Modi during their lifetime. And in the present case, they had taken a contradictory stand. The learned trial court ultimately recorded their finding in para 18 का page 18 का bottom से लेना है, ठीक है? एकदम last line से on the above discussions इसको quote करना है. The learned court ultimately held that the plaintiff had full knowledge with regard to the sale deeds of the defendant, but he did not file any suit for cancellation within 3 years of its execution, and also recorded that the defendants were in continuous possession over the suit land and within the knowledge of the plaintiff and his ancestors right from the date of execution of the sale deed. The learned trial court held that the suit was barred by limitation and also by adverse possession. With regard to possession, by deciding issue number 9, the learned court recorded that the pleading and evidences have already been discussed by deciding issue number 4 and held that the suit land was delivered in favor of the contesting defendants from the date of execution of the sale deeds and recorded that the suit land was not in possession of the plaintiffs. While deciding issue number 3, the learned court ultimately referred to the findings under issue number 4 and held that the suit was barred by limitation. This court finds that the learned first appellate court framed the points for determination in paragraph 13.
Paragraph 12.
Sorry,
Paragraph 12.
paragraph 13. On the basis of the pleadings and submissions, the main point for consideration. Paragraph 13 as follows. The learned first appellate court has also considered all the materials on record and recorded concurrent findings. The court also held, the court gave concurrent findings on the point of limitation also. The findings are recorded as under, हम बता देंगे कौन कौन सा paragraph होगा. There are concurrent findings recorded by both the courts. After considering the materials on record, on the merit as well as the suit was held to be barred by limitation, hopelessly barred by limitation. This court finds no merits in this appeal, as no substantial question of law is involved. This appeal is dismissed.
But at least some observation to that said is valid to that extent. It is well said.
नहीं कर सकते because there is a finding of previous partition. Orders.
Orders with effect Title 19, Second Appeal 252 of 2023.
What is it?
Your Lordship, the defect number 4 to 6 are still pending, Your Lordship. In that the suit, that the value of suit value in the title appeal is different from the suit value in the title suit, Your Lordship. And also in the title appeal order, the title suit number is wrongly mentioned, Your Lordship. So we file an IA to either ignore the defects or send back the title appeal order for correction, Your Lordship. Title suit value is 5,000, Your Lordship.
ID number, title suit is 5,000.
5,000, Your Lordship. And here the value of appeal is given 840, Your Lordship, in the decree of appeal, Your Lordship.
Does it make a difference?
No, Your Lordship. Maybe no, Your Lordship. And page number 4 of the title appeal order, instead of title suit number 9, it's mentioned as 99. That is one of the
IA number 12690 of 2024 has been filed for ignoring the defect number 4 to 6 or in the alternative for extension of time for removal of defect by sending the copy of the decree to the learned court for correction. The defect number office is directed to send only decree of first appellate court,
Yes, decree and the judgment.
decree and the judgment.
Because judgment mentions the wrong title suit number, that is also one of the defects.
The office is directed to send the decree and judgment and decree passed by the first appellate court for necessary correction to the court concerned. The defects as pointed out by the office, we also pointed out. By sending the judgment and decree for correction. Will you deposit special messenger cost? Upon special messenger cost to be deposited by the appellant within a period of 15 days from today. Right? Pose this case on 10th November. Are you closed?
Item 20, second appeal 289 of 2023.
What is this?
My lord, the name of the presiding officer is missing
From?
from my lord the trial court judgment, my lord.
That is the only defect to be removed.
Yes, my lord.
देखिए essay number 289 of 2023. Counsel for the appellant has submitted that the only surviving defect is defect number 5.
Yes.
He submits that an interlocutory application being IN number 12499 of 24 has been filed either to ignore the defect or extend the time for removal of the defect. He submits that the name of the presiding officer has not been mentioned in the trial court judgment. Office is directed to send the trial court judgment to the concerned court for necessary correction. Upon deposit of special messenger cost by the appellant within a period of 2 weeks, pose this case on 10th of November. उसमें 10th November दिए ना?
ये तो नहीं हो सकता।
10th उसका भी 10th November.
उसका 10th
10th of November under appropriate heading. The office is directed shall also point out the defect to be removed. Are you closed?
Item 21, first appeal filing number 378 of 2025.
Yes. Your Lordship, there are two defects. One is that defendant number 13, that is Harnath Mukherjee, has not been, Harnath Chakraborty is not been made party in this appeal, Your Lordship. Your Lordship has sent the judgment on the last day for correction, Your Lordship. It has been received, Your Lordship. It shows that they have been substituted by two legal heirs. One is Geeta Devi Chattopadhyay and Rajeshri Devi Chattopadhyay. There is another defect, Your Lordship, that Geeta Devi has not been made party, Your Lordship. That Rajeshri Devi Chattopadhyay has been made party. Since the substitution has been made in the lower court, that is why she has been made party.
I don't know which.
The corrected judgment is on record, Your Lordship. It has come up.
What supplementary affidavit you have filed?
Your Lordship, we have not filed the original order of rejection of claim, Your Lordship. This is against the review order of.
But original order of rejection of claim has yet not been filed in the
It has
supplementary.
been filed, Your Lordship, with the supplementary affidavit.
No, supplementary affidavit is not contained in the original order. It is still the photocopy.
Certified has not been filed, Your Lordship.
So?
Your Lordship, it will come.
What it
There was no defect regarding this, Your Lordship. We just filed it to bring on record, Your Lordship.
गलत बात तो हमसे बोला मत करिए.
हम certified भी लगा देंगे, Your Lordship.
तो क्यों आप बोले कि supplementary affidavit से file क्यों certify करो?
Certified नहीं की, Your Lordship.
Why did you make this submission at all?
Your Lordship,
Because that's a very important defect. Has to be
No,
removed.
there is no defect regarding that, Your Lordship. The defect is regarding the Party positions, Your
So
Lordship.
you have not filed
Your
the
Lordship
certified
had
copy
pointed
of
out on the last
the.
date.
You have
that-
not filed the certified copy of the
No, Your
order.
Lordship, photocopy we filed. Just on because on the last date, Your Lordship had pointed out that this also may be filed for proper adjudication. Your Lordship.
So where is the certified copy?
Certified we have applied. We will file, Your Lordship.
You have applied certified copy and you have got a photocopy.
No, Your Lordship. For now, we have filed photocopy. This is for the defects, Your Lordship. There are two defects. Both are regarding the party position, Your Lordship. This supplementary affidavit we filed because Your Lordship had pointed out on the last date.
Pro forma respondent number 14.
Yes, Your Lordship.
Who is 14?
Here it is Rajshri Devi Chattopadhyay, Your Lordship. Your Lordship may have the corrected judgment that has come, Your Lordship.
ये पेज 1 के बाद पेज 5 कैसे है? Here are other pages. पार्टी पोजीशन का पेज ही नहीं है इसमें. देखिए सर. आगे पीछे पेज मिसिंग. तो ठीक से अरेंज करेंगे. ठीक से अरेंज करेंगे. Pro forma respondent number 14 is who?
Is the substituted heir of the defendant number 13, Your Lordship. Defendant number 13, Harna Chakraborty had been substituted, Your Lordship. This has come on record in the corrected judgment, Your Lordship.
Let me just see. Where is the corrected judgment? It is the corrected judgment or the corrected decree which is come?
Correct judgment also.
Okay, this is Rashri. Her name is Rashri
Chattopadhyay. She is one of the legal
Rashri
heirs.
Devi. नाम
Rashri
टैली नहीं करते.
Chattopadhyay, Your Lordship.
नाम टैली नहीं करते. It is Rashri Chattopadhyay. Rashri Devi Chattopadhyay नहीं. You correct it.
We connected with the supplementary.
And 25C.
That Harna Chakraborty has not been made
Just a
party.
moment. Defendant, pro forma defendant number 13 has not been made party. Okay, 13 was substituted.
Yes, Your Lordship.
FA filing number 3378 of 2025. With respect to respondent number 14, the learned counsel has submitted that the defect number 25 within bracket B be ignored inasmuch as respondent number 14 was substituted in place of defendant number 13, namely Harnath Chakraborty. However, there appears to be a mismatch with respect to the name of respondent number 14 as per the corrected copy of the judgment of the learned trial court, the learned appellate court. As per the corrected copy of the impugned order, the Harnath Chatterjee Chakraborty was substituted by Srimati Geeta Devi Chakraborty and Srimati Rashri Chattopadhyay. जो भी नाम है चट्टोपाध्याय, एक चक्रवर्ती एक चट्टोपाध्याय.
Your Lordship, Geeta Devi has not been made party because she had expired.
The learned counsel submits that the name of respondent number 14 be permitted to be corrected. वो दे भी नहीं रहे.
No, daily.
Permission is accorded to correct the name of respondent number 14. The defect number 25 is ignored. So far as defect number 25C is concerned, it has been pointed out that defendant number 13 has not been made party. The counsel submits that defendant number 13 was substituted and therefore defendant number 13 has not been made party. She has submitted that she will be Geeta Devi Chakravarti. From where do we get that she has expired?
Your Lordship, with the I have filed a medical certificate, Your Lordship.
When did she die?
On 12 January 2022, Your Lordship.
So you did not bring this back to the knowledge of the court earlier.
The order sheet, no, not the order sheet, Your Lordship.
Died, whether she had any legal heirs or not, who knows? Died on
12 January 2022, Your Lordship.
12th of January 2022.
Yes, Your Lordship.
And therefore, Geeta Devi Chakravarti has not been made party in these proceedings. However, it appears that Geeta Devi Chakravarti had expired during the pendency of the proceedings before the court. But no substitution was carried out. Correct?
Yes, Your Lordship. Corrected judgment also.
However, with respect to with respect to defendant number 13, the defect number 25 within bracket C is ignored. Accordingly, IA number 6174 of 25 is disposed. इसका impact देखना पड़ेगा ना? You are not substituted her at appropriate stage. You were the plaintiff.
Yes, Your Lordship.
You have not substituted her at appropriate time. So, we do not have this recorded, you just see what is to be done. Call the next.
I need a correction.
And you need correction. Post on 10th November. And appropriate.
Order Saturn 22, 2nd April 189 of 2010 along with Saturn 23.
In this case, notices were issued to the point number note 8 to 11 and 26C and D. So far as 26CD, they have appeared. But fresh notice needs to be issued to 8 and 11. 8 to 11 notes.
8 and 9 reside not in Dhanbad. 10 also reside in Dhanbad. 11 reside in Jamshedpur. They are of the appellant side. They are the defendant, respondent. So they are evading. This is pending since last 15 years. This should be served through police station.
Because the respondent number 8 to 11.
8 to
Yes,
11.
8 to 11. 3 are of Dhanbad district. In town itself, Manaita and Dhanbad. Respondent number 8 and 8 and 9. 10 from Jharia, Dhanbad. And 11 is from Jamshedpur. Son and daughters of one Mohammad Raja.
essay number 189 of address सही है?
Address C.
Essay number 189 of 2010. The learned counsel for the parties are present. As per the office note, respondent number 8 to 11 were not found. And so far as the registered cover is concerned, respondent number 8 to 11 were not found. The learned counsel for the respondents has submitted that the respondent number 8 to 11 are evading service of notice, and the matter is pending.
They are legal heirs of one person, Mohammed Raja.
And they are the legal heirs of
Mohammed Raja.
one person, namely Mohammed Raja. उसका कोई उनका कोई legal heir appear हो रहे हैं यहाँ पर?
ये उनका set
He has also submitted that the address given in the memo of appeal is correct. देखते हैं?
Yes.
Let notice be issued to the respondent number 8 to 11 through the concerned police station, for which requisites be filed by the appellant within a period of 1 week. Post this case on
But there are two more IAs.
7th October awaiting service report.
But two more IAs. But IA number 9706 of 25.
For
That
what?
is for deletion, expunging name of respondent number, appellant number 11 and respondent 15. Appellant 11 notes have died issueless. 15 legal years are already on record.
The learned counsel for the appellant has also referred to IA number
9706.
9706 of 2025, seeking deletion of
Appellant 11.
Respondent number
15 and appellant 11.
appellant number 11, who is said to have expired issueless
Yes.
on 5/11/2024, and also respondent number 15, Madina Khatun, who is said to have expired on 24/4/2025, leaving behind legal heirs and successors who are already on record as respondent number 13 and 14. ठीक है, इसमें कोई objection है? The learned counsel for the appearing respondents has no serious objection to the prayer. Considering the submissions, IA number 9706 of 2025 is allowed. The counsel for the appellant is directed to delete the name of appellant number 11 and respondent number 15 from the cause title during the course of the check.
Item 24, second to 62 of 2017.
This matter, the appellant has given the NOC Wakalatnama. Today only I have received the instruction. We will be filing the Wakalatnama for the appellate concern. And he also instructed that since the other parties have received the former respondent in this matter, 10 to 12, so they will be filing Wakalatnama, 10 to 13, they will be filing Wakalatnama in this matter. So, keep it in.
Sir, good enough. This was substantially heard.
Notice was issued to the former respondents. They have also notice was issued to them also last month. So I will be filing the Wakalatnama for the appellant concern.
It's a very short question. Additional evidence has not been considered.
Yes.
The matter has to be remanded.
So we'll file the Wakalatnama meanwhile and we'll assess the
Will you remind me?
1 week.
Second appeal number 62 of 2017. Mr. Subhashi Surin, advocate, appears on behalf of the appellant and submits that he has received Wakalatnama in this matter on behalf of the appellant
Yes.
and on behalf of pro forma
The former
respondent.
respondent is of course, but they are not given the Wakalatnama. In any case,
And
they
he is
will
likely to receive the Wakalatnama from the pro forma respondent numbers
give 10 to 30.
10 to 14. He prays that the matter will be posted next week. Post on Monday, Tuesday,
23rd,
okay, Wednesday.
Thursday.
रिकॉर्ड आ गया है रिकॉर्ड नहीं आया रिकॉर्ड कॉल पर